This does turn out, this does. Jerry's already there, so how do we get that up?
So. It says, present.
We've already got one guest.
All you're gonna have to do is just hit the next arrow. They don't, all they see is the PowerPoint, so.
Got it. Awesome.
By the way, if you ever need another pair of scissors, there's an open here.
No, my mic's. Welcome, everybody. My name is Jeff Wilt with North Star Law Group in the Construction Law Division. Many of you know me personally or have worked with me in the past. In any case, we've got a few more attendees. We're going to give it a couple more minutes here while we wait for a couple more registrants to log on. A couple housekeeping items. If there's a chat box at the top, some of you may not be as tech savvy as others. If you have any questions, you can click into the chat box and send a question. Short term, if you're having some technical problems, you control your microphones. So if you could keep your mics off for now, then it would be helpful to get through the presentation, because at the end, we're going to do a Q&A. If something catches your attention or is of special interest, then go ahead and send the chat. My assistant Cindy is waiting in the wings to be able to direct me on that. So we're just going to give it a couple of more minutes here. I'm hopeful that everybody can hear me. So I'm just going to go down and say first names. I'll keep your last names. I won't reveal your last name, just so that there's respect to privacy amongst all participants. Jerry, I assume you can hear me. If you can't, send me a chat. Mark, same thing. Zach, assume you can hear me. Delilah, Jim, Amanda, Lisa. It is 12:01. We'll give it another minute. I want to be respectful of everybody's time. I realize that We're doing this over lunch and the busy time of year. So I appreciate everybody taking the time out today to participate in this, what we feel is a very, very important piece of legislation and new law that was implemented in the state of Minnesota. So we'll give it one more minute here and then we'll get going. Just going to log off my microphone for 30 seconds to ask a quick question to my team. Thanks. All righty, we're back on here. Once again, my name is Jeff Willett with North Star Law Group. Most of you that are attendees today know me personally or work with me. Some of you may have not. I'm one of the 4 partners here at North Star Law Group. I had a construction law. My background was a former contractor and worked in commercial construction for greater than 25 years. And I also took the Minnesota BC exam in 2004 and passed that, and had just about every certification one can imagine, including but not limited to an OSHA 30. So with that, just to recap real quick, at the end of this thing, we're going to do a Q&A. So if there's any questions that pop up, just let me know. And one other housekeeping item, should somebody fall off, I get it. I mean, things happen, you get a phone call and there's an emergency, you need materials, or there's a problem in a site. We're recording this, and so we'll have this material that my team will be able to get to you after this meeting. So here we go. The 2023, the subject matter today is the 2023 Construction Workers Wage Protection Act. It's what we will call the Act throughout the remainder of this presentation. And the Act is a powerful new twist on an age-old law. So we've already had laws on the books, 2 major statutes, the Fair Labor Standards Act and the prompt payment statute, that govern many of the principles that we're going to talk about today. I assume all of you have some familiarity with the prior law, and that prior law is part of the new law. So it's very much still applicable. It's just the net now that has been cast over the construction industry has gotten wider, and it's much more inclusive than it used to be. Next slide. So recently, a little over a week ago, Governor Walz signed into law the Act, effective August 31st, 2023. So it's just about within 60 days or so, this law is actually going to start being enforced. And the premise behind it was to protect construction workers in 2 ways. 1, from being misclassified as independent contractors, or 2, current W-2 employees that are being cheated out or defrauded of wages, benefits, overtimes, fringe, and things like that. The statutes that I referred to earlier, the Fair Labor Standards Act, which is Minnesota Statute 177, and its companion statute, Minnesota Statute 181, governs many of these principles that are incorporated into the Act. For example, Minnesota Statute 177, and I wouldn't worry about these statutes because we're going to go over this material enough. We're at the end of the day here, and this should take 30 or 40 minutes maximum. You'll have a good idea of where this thing is headed and where you stand relative to the new rules. So Minnesota statute allows for examination of all records of employers or anybody perceived to be an employer, and that's an important concept to remember throughout the remainder of this presentation. And Minnesota statute 181.723 defines what it means to be an independent contractor and not an employee of the person for whom the individual is performing services in the course of the person's trade, business, profession, or occupation. And such individuals only in IC if they meet the 9-point checklist standards that are defined in that statute. Now, the 9-point checklist, many of you probably caught that phrase catches your ear. An individual, an independent contractor, each and every one of you who are contractors are independent contractors, meaning you have an office or a shop or an office at home. You have an FI, federal identification number, a Minnesota Department of Revenue, Minnesota ID number for taxation purposes. You operate with contracts as between the entities that you do work with. You incur expenses on those projects. You're responsible for your work and will be held responsible thereof if there's an issue with the workmanship or materials on your sites. You're under contract on those jobs with your entities that you're in relationship with. You incur profit or loss on any of your projects. Your business incurs ongoing liabilities and expenses that you're responsible for, and you are responsible for the success or failure of your business. So that's what an independent contractor truly is. And the state now has implemented this act to avoid independent workers being classified as independent contractors to avoid the Fair Labor Standards Act. So there's a couple of key definitions here, and this is one of the major changes in the old law versus the new law. So under the old law, an employer was, just as it sounded, the employer was the individual that hired a W-2 employee. Well, today, under the new law, the term employer has changed, it's shifted, and it now includes, of course, the employing entity, but it will also include an employer, or rather a contractor that has assumed a subcontractor's liability under the Act. It's an important concept to remember. That refrain will be beat throughout this entire presentation, so you don't have to worry about that now, because we're going to come back to this concept of assumption of liability. Contractor is the traditional understanding, connotation of contractor still applies, but now it also includes construction managers, of course, GCs, joint ventures, which means it moves into the ownership class on projects, particularly commercial projects, that entered into the contract with an owner. A construction contract under the Act is defined as any and all contracts in the construction industry, whether that's residential or commercial, except for a couple of exceptions in the residential sector. And we'll drill down on what that means later on in the presentation on the carve-outs for residential construction. As an aside, just as a quick note, all commercial construction is included, soup to nuts. So 100% of commercial and a large chunk of residential is included under the Act. Owner, now this is something that's different now as well, because owners can be considered to be contractors and therefore employers by the assumption of liability, even without a contractual relationship in the vertical hierarchy of a construction project. Owner, site development, hires GC, call them a prime, who hires tier 1 sub to do, let's just say, roofing, that hires another subcontractor below them. So you've got four links in the chain: owner, prime, tier 1, tier 2. That owner, theoretically under this Act, could be construed to be the employer of the tier 4 workers if said workers are not either independent contractors, and that means each and every one of them, satisfying all 9-point checklist requirements, including but not limited to filing taxes annually, which is another important consideration, or they're a W-2 employee. That's it, independent contractor or W-2 employee. And if they're W-2 employees, it's incumbent upon the vertical chain to make sure that those employees are being paid any overtime, it's plus 40, and their fringe benefits, no more banking hours. That world is dead. Next question, or the next subcontractor. This is the role, the definition of subcontractor hasn't changed, but what has changed is the last 4 words in it. No privity required. Under the old law, the old wage protection law, if in the vertical chain, prime contractor, prime owner, GC, tier 1, tier 2, if there was no contractual relationship at each level in that chain, then those above the contract that weren't in contract with the lower party, they couldn't be held liable. They couldn't be held responsible for any wage theft violations. That has now changed. So really, at the end of the day, the 2 biggest changes are, what does it mean to be an employer and who can be held responsible? And the fact that there is no longer privity required. So the innocent contractor doctrine has been waived. We'll unpack this more as we go down the line here. So the policy behind the act, Minnesota's legislation on wage theft was drafted and basically adopted literally from the California Labor Code, Section 218. You don't have to worry about what that code means. I can say a little over a week ago, Courtney and I, was one of my partners, we're at Housing First, which is a major nonprofit organization that seeks to advance the interests of merit shop contractors in the state of Minnesota, to make sure that the rules of the game are as fair as possible, because Minnesota is one of the most regulated states in the United States with respect to construction, building, and remodeling. And I met one of the lobbyists from there who had spent over a year lobbying against many of the components of this law. And he said it was literally picked up from California and dropped here. And so right now we're turning our eyes to California and looking at some of the case law in California, because you can bet when wage theft violations arise out of this, and the Department of Labor and Industry, as we'll get into, governs this. They've hired 17 new investigators recently in their labor division. So you can bet enforcement is going to arise in this. And later on in the program here, we've got some case studies that will, I think, help to exemplify the issue and really impact it in our minds. I think it's important to note that there were 2 major organizations, entities that were involved in propping this. The local trade unions lobbied heavily to have these rules implemented. And we can debate on whether or not these rules are fair or not. At the end of the day, they are what they are, but the union was really pushing for this, particularly in the commercial sector. And then there's another organization, it's a nonprofit organization that works is closely aligned with the unions. It's called SUDL, Centro Trabajadores Unidos en la Lucha. And La Lucha means in the fight. So it's a nonprofit organization primarily geared towards educating the Hispanic workforce on this law, and really is stimulating a lot of the litigation and wage theft claims against owners, employers, contractors. So I think it's notable to bear that in mind. So in California, one of my clerks, John, did some recent research on, we're trying to get a pulse on what's happening there so we can get an idea what might happen here. So this was a commercial contractor. They have their commissioner, like we have our commissioner of the Department of Labor and Industry. And JPI Construction is a pretty big contractor in California. They were clipped for $1.7 million in wage theft violations on one project. The claimants, and the claimant in this case are the workers or their workers' representatives, were paid a flat rate that excluded overtime. Excluding overtime is considered to be wage theft. And so on top of the wage theft, the wages themselves, the back wages and all the fringes and everything else that they had to pay, they also got clipped with $143,000 worth of fines. Now, that's just one example in one case. So another California example, real fines in California, Universal Structural Building, a subcontractor, so this is now the next tier down, provides concrete building services to commercial sites, was investigated on 2 projects, and their workers stated that they were not being paid correctly. So assume this: if a claim is made, the eyes are going to be on you, not the worker. Upon conclusion of California's investigation, USB employees were owed nearly $500,000 in unpaid wages and penalties, and another large fine, in this case, a little over $100,000. So, these can be extraordinarily substantial damages, and if you're not expecting to incur these damages, have a crippling effect in your business, as one might understand and appreciate. So, under the old act, as well as the new act, the enforcement arm of the state of Minnesota is going to be the Department of Labor and Industry and the commissioner and its agents. Now, there's another interesting component of this particular act, which was actually part of the prior act, but you had to really, really dig to find it. Now it is more prominently defined. When there is a wage theft claim, and the wage theft claim is greater than $1,000, that is technically a felony and could be charged up by the Attorney General's office. So we'll get into that here momentarily. Sorry, I had a prompt here from one of the guests that had to step off. The policy behind the act is the goal is to stop construction workers from being misclassified as independent contractors or ICs, as we talked about earlier. But who are not actual ICs. We'll get into that in a moment, because they don't qualify under the 9-point checklist. They're simply independent contractors on paper, but when an investigation is done and an analysis of their paperwork is evaluated, they don't qualify. 2, simply put, if a worker is not a W-2 employee or does not satisfy the 9-point checklist under the rules, including proof of payroll and taxes and all that stuff, then the worker has been misclassified as an independent contractor. Finally, under the laws, these workers are then treated as employees of the contractor for whom they're doing work, and direct privity or a direct relationship is no longer required. So that innocent contractor doctrine has been waived. That's a crucial distinction from the prior act. The enforcement arm, we talked about this a little bit briefly. The commissioner of the Department of Labor and Industry may enter and inspect the place of business, and they don't have to give you a lot of a notice. And they can interview all the employees, they can examine all the employee payroll records, make copies of any and all records, and then use all of that data to seek to do enforcement in the wage theft component. And I would also bear in mind in this, because I do a lot of DLI work, primarily on, contractors that are contracting without a license or get tagged or do things that they shouldn't be doing. But you can bet on, it's guaranteed that if they find something else, so for example, if you're an employer and you don't have a written safety program under the OSHA rules, that will get glommed on. So it's sort of a catch-all that this rule brings into the game here that increases the likelihood that they're going to find something if you're not keeping accurate records and good documentation and following good contract and construction management skills. Let's see what else here. All contractors, hiring owners are subject to the act, and we'll talk about that a little bit more down below. And that would include the companies that hire construction workers, whether directly or indirectly. And both of those parties, the contractors or the hiring owners or companies that hire the contractors, share or assume the liability of the subcontractor downstream that they hire. Okay, so that's an important distinction. Now, a contractor entering a construction contract shall assume and is liable for any unpaid wages, fringe benefits, resulting liquidated damages. That's a new concept. Liquidated damages, think of double damages. If you owe $10,000 in back wages, they double it under the rules, so now it's $20,000. By any subcontractor at any tier, as we talked about before, or for the contractor or its subcontractor for the misclassified worker's performance of labor. Very important distinction. Assumption of responsibility or assumption of liability. So we touched on that above, but I want to reinforce it now. As a contracting entity with anybody below you, you assume the labor risk of that lower tier subcontractor. Here, the GC or owner assumes the liability and will bear all of the responsibility jointly and severally with the lower tier subcontractor. Joint means together and several means apart. So to unpack that, joint and several liability is a term for responsibility under the law shared by two or more parties to a lawsuit. In this case, employees can bring a lawsuit against the employer. A wronged or harmed party, this is the employee, may sue any or all of them in their individual or group capacity, as well as collect total damages awarded by the court, so this is the back pay and everything related to it, against one or both of them or all of them. So that's the joint and severable. In such cases, responsibility for the total amount of damages awarded could be shared by all or simply solely one party. It's a very important distinction. It could impart a tremendous amount of financial liability on the offending contractor. So due diligence is going to be utterly critical. Implications, briefly. General contractors now assume the liability for wage theft violations of any contractor, regardless of the tier that is acting under the GC. No privity is required. The liability cannot be contracted away by an indemnification clause. The rule said there is no evading potential liability. If a GC is sued for wage theft violations, then the GC can be held liable without any contractual relationship, no privity between it and the subcontractor. Finally, any employer who's committed a wage theft violation may have to pay the employee's reasonable costs, disbursements, witness fees, and attorney's fees. So this means you not only cover your own attorney's fees, but you're going to cover theirs as well, plus the damages, and you could be glommed on, and they could glom on criminal penalties and felony charges. Exceptions. There are two exceptions. We talked about those at the top of the presentation. Two exceptions to this rule. So again, just to reiterate, all commercial workers included by the Act. Some residential is excluded by the Act, and here are the two exceptions. The two exceptions in which this new law does not apply are the following. Number one, residential home improvements, single-family dwelling owner-occupied. Repeat, residential home improvements and remodeling, single-family dwellings, owner-occupied. So, residential home improvements or remodeling, single-family dwelling, rental, the rule doesn't say it doesn't apply. Two, second exception, new construction. New con of a single-family dwelling or an owner-occupied two-family dwelling, duplexes, don't apply. So with respect to the duplexes, one half, left or right or top or bottom, has to be owner occupied. Number two, on the new construction exception, it doesn't apply to small developments, typically custom builder, presumably, where it's 10 units or less. But again, single family dwelling, owner occupied. Essentially, what we're distilling, we're drawing out of the statute is all commercial and any income producing properties, including common interest communities, HOAs, townhouse projects, those are all included here. So meaning when I say included, they're governed by the Act. So monetary damages. We talked earlier a little bit about liable employers of misclassified employees shall pay back wages, tips, and everything that they're owed, less that which you can prove was paid. So prime contractor pays subcontractor, who then pays the lower tier workers. That GC can prove some money was given to the lower tier subcontractor, and that money then went through to the workers. That would be deducted off of the bill. Such liable employers must pay the harmed workers the same amount due as double damages. Again, 10 becomes 20. Another important factor here is the attorney's fees. They have no reason not to bring these claims, especially when they're being coached by the union or SUDL to bring these claims, because if you're found liable, you've got to pay their attorney's fees. And then finally, again, as we talked about before, if the wage theft is greater than $1,000, it's a felony and it's subject to criminal prosecution. Now, it doesn't mean that they're going to prosecute in every case, but you can bet early on, they're going to try to make an example of a couple of contractors, which we're going to get into in a moment. So possible penalties, the criminal conviction, up to $100,000 in fine for felonies and up to 20 years in prison. These are the extremes. They're not the means or the averages. I don't think this is going to be the case, but this is what the felony rules say. No way out. We're in a tunnel here. You can't evade responsibility. What you can do is make sure that you've got good contracts in play, which we'll get into at the end. And you can't create an agreement whereby you tell the subcontractor that they're going to have to indemnify you should you be claimed as a wage if you're held liable for wage theft for their conduct. Now, this particular graphic here, I think, is important so that you can see not so much the numbers, because these numbers are grossly underestimated in my opinion, but just to show that the state of Minnesota and the major counties in the state are looking into the data. They're going out and evaluating this data. So they're on the hunt is the point. And I think to corroborate that assertion that they're on the hunt is what DLI is doing. Combined with this law and building up the Army to go out and investigate, you can assume that they're looking to reduce these numbers on an annual basis with respect to the estimated wage theft that occurs at an annual basis in the state of Minnesota. Now, we get into real people and real problems, and we're nearing the end of this, so we're just about done. Appreciate your patience so far. This Abel Sostaito, he was a worker on a commercial site. This site just happened to be right adjacent to, it's actually the parking lot area and adjacent to the Vikings' new practice facility in Egan. And the reason that we cited this example is because it just goes to show you how close to home to the big players in the town. Talking the NFL here. Now, the Vikings weren't involved in this, but it was on a property that they lease. So you can see that these claims and these people are bringing these claims, and I assume the claim was legitimate, and it's unfortunate this individual incurred it and had to fight for his or her rights. In this case, it's a he, but you get the point. This is an interesting case. So a couple years ago, many of you may have heard of Joyce and Leroy Mayer of Merritt Drywall, primarily commercial, primarily common interest community and multi-housing drywall contractor, as I said. The union was on him pretty heavily. The genesis of the investigation and the prosecution was done by Mike Freeman, who is the county attorney, Hennepin County attorney. This was on the news. They were doing about $8 to $10 million a year annually in drywall, mom and pop shop. They got into some trouble with workers coming in. They were shuffling them in and setting them up with LLCs and paying them cash or paying the LLC when the workers thought they were employees. So, they definitely broke some of the rules. But the point is at the end of the day, Joyce and Leroy Mayer are done working, so their business is over. Number one. Number two, they got clobbered with a huge fine in this case. They had to pay Federated Insurance back greater than $300,000. They were clipped with a fine of $30,000, and they were on house arrest, I think, for 4 or 5 months. It's another real person and real problem, Ricardo Batras. He worked in a site with some fairly well-known commercial contractors. He was what you call a labor broker. Mr. Batras was clipped with a labor trafficking claim, human rights violation, and got 4 months in prison and 5 years in probation. And I've seen and known lots of guys like Mr. Batras. And under the old rules, he was able to get by with a lot. This was about 2 years ago. Now, the dynamics of his case are slightly different than the Joyce and Leroy Mayer case, but at the end of the day, we're showing these case examples to underscore the fact that these investigations are real, affecting real people in real time with real money and real penalties. So, remedies. There is hope, and North Star Law Group can help. three primary ways that you can help your business and have as much adequate assurance as possible to avoid ever getting a wage theft claim. Number one, you got to have legally sound contracts. Now, each and every one of you, most of you have done your contracts or have had some, or have reviewed your contracts. But for those that you haven't, take a look at what you've got relative to what we talked about today, or you can send them to me. We'll do a free review. Having said that, we are drafting some new terms. I don't think any of you will probably need new contracts as a whole. Just needed a couple provisions added. And these provisions will be provisions that will be related to any downstream parties that you hire. Because you can bet if you're subbing from a GC or a prime on a commercial site or even on a larger scale residential site, they're going to flow it down to you with the same or similar provisions that we're going to be adding for our contractor clients for their contracts. Now, one thing that is different that you're probably going to have to start getting used to under the new rules, if you are engaging lower tier subcontractors. If you're a 100% employee-based organization and you're, paying per your employee offer letter, and if there's overtime, you're paying overtime, and whatever you've got for your benefits in your employee handbook and whatever documentation you have between your employees, you don't have a lot to worry about. It's when you're hiring somebody or you're being hired by somebody that the rules of the game change. But that's where the contract management comes in, good bookkeeping comes in, and documentation. I have a lot of experience in that area. That's something we can help you out with. And then competent systems. Remember, I talked about the wide net. If there's an investigation, you can they're going to want to see, because if there's an investigation, it's assumed that somebody took on the role as employer-employee relationship. Even if they weren't your people, they were the lower tier subcontractor. So now you're going to have to look at making doggone good and sure you've got some sort of written devices between you and your subcontractors, a quasi-employee handbook. Safety programs. You got to have written safety programs under the old law. You can bet for sure if you're investigated, they're going to want to take a very good look at your safety programs. And it's not just the written safety program, it's the implementation thereof of the programs, including PPE, personal protective equipment, training on the PPE, and everything related to that. And then, inspecting your sites. Just because you train somebody doesn't mean, if you have a rule, a stop sign, and there's a cop on the corner and people keep flying through the stop sign and the cop never pulls them over, well, the sign, which is the law, is no good because there's no enforcement. The same is true with any of these programs. Good contracts, good safety programs, good bookkeeping. You could have great rules of the game that you operate by, but if you're not enforcing those rules and inspecting enforcement on those rules, well, then the rules that you have are no good. So that is the end of the presentation. And at this point in time, we're open to questions. You have control of your mics. What I think, we're about 30 minutes into this thing so far, and that's exactly where we wanted to be time-wise. So that we had a few minutes. I didn't want this to be any more than 45 minutes for your sake. I'm happy to stay on for the hour, but I understand that each and every one of you need to run a business or a component of a business. So does anybody have any questions whatsoever for right now, whether it's this subject matter or related material? Because you got me on the mic, so now is the time for free legal advice, which is rare.
Can you hear me, Jeff?
I can. Yeah, go ahead, Jim.
Hey, I've got two questions. Number one, the employer assumes the subcontract responsibility, okay? There's no privy required as far as the new law. Do we have the right then to dive deep into the pay of the subcontractors? In other words, say that our subcontractors has got 5 employees. We can only assume that he is paying his employees correctly or he's not paying his employees correctly, even though we are paying the general or the subcontractor his stipend for, or his PO for that work. Can we demand to see the paychecks or the hourly rate or the sign off or to make sure that his people are getting paid correctly?
That's a great question. So to answer that question is yes and yes. So of course, we know the assumption of the liability for the upstream party, for the subcontractor's misconduct, let's say it, wage theft. And can the non-offending or the hiring contractor demand inspection of the subcontractor's payroll records or pay records? The answer to that question is yes. The statute obliquely refers to that, so they touch on that, but by contract. And that's why I said this firm is working on some new contract provisions to be incorporated into a legally protective contract that will have that language included in it. Many of you probably already have. I know a lot of the contracts I drafted before, even as of yesterday, had language in it that grants that power, but it doesn't really hone in on the specificity of that. And so now I'll give you an example of what we're talking about is you'll have a new term, Jim, and everybody else in your contract that'll say, at certain intervals, these are your milestones that you need to provide us with proof of payment. So for example, the bookkeeping side, the 5 guys you're talking about, you want to know the names and social security numbers, the last 4 digits, or I don't know, the employer can give that. That's a different rule. But who are these workers? What are their names? Okay. And then we want to see record of how they're being paid and when they're being paid. And so part of the responsibility of somebody like yourself, Jim, will be making sure that, if that worker's on your job site and you've hired a sub, and these guys are working 80 hours in that week, and they are, but they're only being paid 40, well, that's a problem because now you have actual or constructive knowledge that they're not being paid. But to answer your question directly, yes, you can ask for proof, and you are going to be asking for proof because you must ask for proof. Otherwise, you will be liable for the lack of proof. Does that make sense?
It does. So my second question is, now that CUTL is deeply involved in this, and I imagine they're jumping up and down in joy. Not only should, in my opinion, or the question is should we in fact, even on the non-regulated residential single-family homeowner-owned projects, should we not have something in our subcontract agreements with these subcontractors to make it known that this is a concern of ours, and that they have to have a safety program and everything that goes along with it? Is this something that should be incorporated into that non-regulated portion of this law?
So another great question. Most of that data is in most of your contracts, at least any ones that I've been involved with. The problem is there's been no enforcement of those clauses or terms in your contracts. So we're going to need to really think about those relationships. But to answer your question directly, yes, those should be in your contract. If they're not in your contract, and if they are in your contract, they need to be enforced. The problem is most of these guys and gals, particularly in the residential sector, but it certainly exists in the commercial spectrum. It was out there. As you know, most of them don't have this stuff. So then the question becomes is what happens to these workers? What's going to happen? Some of these workers, let's just face the fact. This is rubber meeting the road here. The bulk of these workers are Latino, number one. Number two, many of these workers are undocumented workers, hard workers, great workers. Everybody wants them, including the union. But the union has a problem because they can't e-verify these people because their socials aren't checking out. Now, as a general rule, you can't ask about their social security number. That's discrimination. Somebody gives you a card, an identification. It looks legit. You have to assume it's legit. But, so what's going to go on with these workers if that lower tier subcontractor, Jim, you were just talking about, can't get socials on them, or these guys and gals, there are issues with bringing them on. likely there's going to be some peel off. Some will probably peel off to states that don't have rules like this. Those that are, on the scale of legitimacy, let's just call it, are going to have to step their game up. And, you can't, I guess at the end of the day, you really can't blame the state because a lot of money is being poured, that is being paid out, billions of dollars annually nationally. By the way, this legislation, this is becoming national. This is the most comprehensive legislation in the United States on construction law. The wage stuff, this new rule, this act we're talking about here. This is the Minnesota model. This is the leadership of the United States. And from Harvard to Stanford, all of these think tanks are studying this. They are sick and tired of the dough not being taxed. That's the bottom line here. And the union is sick of losing work to contractors that are using undocumented workers, particularly in the commercial world. And the state gave a carve out to some residential contractors. That's the bottom line on this deal. So yeah, Jim, we're gonna have to make sure that the terms and enforcement of those contract provisions and the proof. That's the cop sitting on the corner actually giving you the ticket or citation when you run through the red light. So I hope that answers your question. And by the way, if things come up for you guys, in the next week or so or whatever, email us. We'll get you the data and answer the questions. I think we have another question here.
Okay, go ahead.
Go ahead, Lisa. Hi, Lisa.
Yeah, it's a quick question. So does that mean that lien waivers are no longer relevant?
Well, so that's a very good question. Hadn't even thought of that. So a lien waiver, is a lien waiver relevant? Well, the lien waiver would be relevant as against the subcontractor claiming you haven't paid them. And that's part of these issues that Courtney and I and several of the other lawyers and some of the clerks are working on is if the rules under the Wage Act say that you can't indemnify, well, indemnification means reimbursement. But yet, 2 sentences later, the legislature says, oh, but by contract, you can still protect yourself. Well, what does that mean? So we don't have any case law to figure out what that means, so we have to try to guess and work with our network and other attorneys in the construction bar. So at the end of the day, there are some things that are still going to be, this is going to be a work in progress. This is brand new. We're talking a week old here. But with respect to lien waivers, I would still get your lien waivers because that's going to at least absolve, at least protect you with respect to the owners of the property. Whether it's commercial or residential, and at least you'll have that lien waiver that way. It's not going to protect you against a claimant, a worker claiming wage theft, even if you paid the sub. Remember earlier on in the slide, Lisa, I had said that whatever you paid gets subtracted from the wages owed. So the lien waiver will still be important. In fact, I would argue that the lien waiver in part becomes part of the record that establishes in the bookkeeping that you did in fact make said payment. Make sense?
Yeah, that makes perfect sense. Thank you.
Anybody else?
One last thing I'd like to interject, and this is just a comment. It seems as though this law is starting to erode the former 9-point independent contractor provision. It's gnawing away because it contradicts some of the 9 points that are required at this point.
Yeah, so that's interesting. I mean, I have the 9-point checklist here. I mean, I look at it all the time. What the 9-point checklist is meant to do. And it's the 9 points are a series of balancing tests. So no one of the 9 points is greater or stronger than the other. And they're all sort of balanced together. And they're actually derived from the Internal Revenue Service. And then the states adopted them to establish or try to provide a basis for who's a legitimate independent contractor and who's trying to pretend to be an independent contractor. So case in point, labor, Ricardo Batra is kind of a person we'll go out and form an LLC, single member LLC. We'll go out and get a ghost policy on the business so Ricardo Bottress's Roofing has a workers' compensation ghost policy on the business, which means no individuals are covered by the policy because, of course, as a single member LLC, he can waive himself from workers' compensation coverage. If there were two people, he couldn't do that. So they have a shell company, and then they go out to the Home Depots or wherever they get their labor, and they bring in these group of laborers, and they claim that these laborers are their employees. But in reality, to the upstream contractor, but in reality, they're just paying these guys or girls cash. I mean, literally $100 bills. And so at the end of the day, while what you say is true, Jim, that some of these provisions are eroded, there's at least enough of them that remains that gives the state enough to hold on to say, well, wait a second now. You're not even paying this person in a check form, right? You're just giving them cash. There's no way to track that. So at the most fundamental level, which is the exchange of money as between a worker and an employer or a hiring entity, you don't even have that. So, while I don't disagree with what you said, there's just so many of the fundamentals being missed at the bottom level of this, and the state is done with it. But again, there are the residential carve-out exceptions.
Thank you, Jeff.
You're welcome. Anybody else? Well, I don't see any other lights popping or hands showing. So I just wanted to, again, thank everybody for carving out their lunch today. It's 12:47. We started 3 minutes late, so we're at about 45 minutes. Again, any questions that should arise thereafter, anything, send me an email, send Cindy an email. She's the one that sent the link out, and we'll get you the answers. Meanwhile, best of luck out there, and we're here to serve should you need us. Thanks for your
Thanks, Jeff.
time.